All right, ready to dive in. Today we're looking at Philippine courtroom procedure.
Sounds intense.
Well, you gave me this stack of notes on rules 30 through 33 of the rules of court.
Yeah.
Trials, consolidation, commissioners, demurrers.
All the good stuff.
The stuff legal drama is made of, right?
Exactly.
I'm no
Don't
lawyer,
worry, you don't need a law degree to follow along.
but I do love a good courtroom drama.
We're gonna break these rules down and see how they play out in real life.
Perfect. Let's start with Rule 30 then.
All right, Rule 30, trial.
So this is all about, the actual trial.
Absolutely.
Laying out how it all works.
It's like the blueprint for a trial.
Okay.
It covers everything.
Everything.
From scheduling to presenting evidence to what happens if you need to postpone a trial.
Postpone. Interesting.
And something that Rule 30 really emphasizes is this distinction between a trial and a hearing.
Oh, okay. So what's the difference?
Well, a trial is specifically about presenting evidence,
Okay.
while a hearing is a broader term.
So a hearing could be about a lot of different things.
Exactly. It can include things like pre-trial motions.
So like arguing different legal points, but not necessarily presenting the evidence yet.
Right.
Okay, got it.
And sometimes,
Yeah.
lawyers try to get creative with postponements.
Oh, I bet.
But the courts are usually pretty strict about the timeline for presenting evidence.
I bet there are some crazy stories about that.
Oh, absolutely.
Have you ever seen a case where a lawyer tried to use some ridiculous excuse to postpone?
I remember one case where a lawyer claimed their client was too sick to attend the trial,
Oh.
but then someone found the client posting vacation photos on social media.
No way!
The judge was not happy.
Yeah, that's gonna backfire.
Big time.
Okay, so Rule 30, it sets the stage.
Test the stage, yes.
What about Rule 31?
Consolidation and severance.
Consolidation and severance, what are those?
Okay, so imagine you're organizing your closet.
Okay, I can do that.
Consolidation is like grouping similar items together.
Like all my shirts together
Exactly. Shirts with shirts, pants with pants.
to make things more efficient.
Exactly. And severance is the opposite.
Okay.
It's like separating your work clothes from your party clothes.
Because you don't want to mix those up.
Right. They serve different purposes.
So, consolidation in a legal sense would be merging cases that have common questions.
Exactly.
Yeah.
Like, let's say there's a car accident with multiple victims.
Okay.
Instead of having separate trials for each victim,
Right.
the court might consolidate those cases to streamline things
Makes sense.
and to make sure the decisions are consistent.
That seems much more efficient.
It is. Saves time and resources for everyone.
And it's probably less confusing for the jury, if there is one.
That's a good point.
So consolidation is about efficiency, but also fairness,
Right.
making sure similar cases are decided in similar ways.
Yes.
And then severance would be like splitting things up when the claims are too different.
Right.
Okay, so back to our car accident example. What if one driver was clearly reckless, but the other one was following all the rules, but had a mechanical failure?
That's a perfect example.
Because that seems unfair to lump them together,
Exactly. Those claims might be severed.
to make sure each driver is judged on their own actions.
Exactly.
Okay, I'm starting to see how this works.
It's all about balance, really.
Balance between efficiency and fairness.
Right.
Okay, what's next?
Rule 32, trial by commissioner.
Trial by commissioner, that sounds serious.
It is. Think of a commissioner as a specialist,
A specialist.
someone who's brought in to assist the court.
To assist with what?
Well, with complex issues.
Okay.
Let's say you have a business dispute
Ah,
with really complicated financial transactions.
that kind of thing that would make my head spin.
Exactly. And the judge might not be a financial expert,
Right.
so they can appoint a commissioner who is,
Someone who can actually understand all that.
yes, they analyze the evidence and present their findings to the judge.
So they're like a translator, almost
A translator, that's a great way to put it.
helping the judge understand the really technical stuff.
Precisely.
And then the report has to be super detailed.
It does. It lays out exactly how they reach their conclusions.
Can't just be, trust me, I'm an expert.
No, definitely not.
Okay, that makes sense.
And finally, we have Rule 33,
Demurrer to evidence.
demurrer to evidence, yes.
What is that all about?
This one is a bit of a challenge.
A challenge.
It's a challenge to the strength of the evidence presented.
Okay.
So imagine a situation where the plaintiff presents their case,
Uh-huh.
but their evidence is really weak.
Like full of holes,
Exactly, like a house of cards.
about to fall apart.
Right, so the defendant could file a demurrer to evidence.
What would that do?
They're essentially arguing that the plaintiff hasn't proven anything.
So it's like saying, game over, we win, you haven't got a case.
Well, it's a bit more complicated than that. It's
Yeah.
risky, because if the judge disagrees, the trial continues.
And you've shown your hand too early.
Exactly.
So it's a high-stakes gamble.
It is. It can have a big impact on how the trial plays out.
Okay, so those are the 4 big rules.
The basics, yes.
So what happens next? Where do we go from here?
Back again with the rules of court.
Back to untangling these rules that shape what happens in a courtroom.
We're going beyond just the basic definitions now.
Yeah, we're going to see these rules in action.
Exactly.
So let's go back to Rule 30.
Right.
It sets out the schedule for a trial, right?
It does.
And it mentions these strict timelines for presenting evidence.
Yes, very strict.
It's like a legal countdown clock.
That's a good way to put it.
But what happens if something unexpected happens?
Like what?
Something that throws the whole schedule off,
Uh-huh.
like a force majeure event.
Oh, you mean like a natural disaster or something?
Yeah, or even a pandemic.
Right. Things happen that you can't predict.
Exactly. So what happens to the trial then?
Well, the rules of court actually have a provision for that.
They do.
It says that if the trial is interrupted by a force majeure event, the day of that event is not counted in the schedule.
Oh, interesting.
So the clock kind of pauses.
And then starts again when things get back to normal.
Exactly. So nobody is penalized for something outside their control.
It's like a safety net.
It is a safety net built into the system.
Okay, that makes sense. You wouldn't want a typhoon to derail a whole trial.
Right.
All right, let's move on to Rule 31.
Consolidation and severance.
We talked about consolidation being like organizing your closet, grouping similar things together.
Right.
Can you give me an example of how that actually works in a case?
Sure. Imagine a situation where there's a car accident,
Okay.
but there are multiple lawsuits coming from that one accident.
Multiple victims, I'm guessing,
Exactly. Multiple victims with different injuries,
and different claims.
but they all stem from the same event.
I can see how that would get messy.
It can, and consolidation is a way to manage that.
So the court can handle all those claims together
Exactly. It streamlines the process.
and saves time and resources.
It does.
And it probably helps ensure that the decisions are consistent.
That's right. That's a key benefit of consolidation.
It's not just about efficiency, it's also about fairness,
Absolutely.
making sure that similar cases are treated similarly.
That's the goal.
Okay, and then we have severance, which is about separating claims that shouldn't be grouped together.
Right. Splitting them up.
When would that happen?
Let's go back to our car accident example.
Okay.
What if one driver was clearly reckless, speeding and weaving through traffic,
Uh-huh.
but the other driver was following all the rules but had a sudden mechanical failure?
Ah, so they were both involved in the same accident,
Yes.
but their actions were very different,
Very different. And that's where severance comes in.
to make sure that they're each judged on their own actions.
Exactly. Not lumped together with someone who is clearly at fault.
So you avoid guilt by association.
Right.
Everyone gets a fair shot.
That's the idea.
Okay, I'm following you. Now, what about Rule 32, trial by commissioner?
Ah, the commissioner.
We talked about how they can be like a translator explaining complex issues to the judge.
Right.
But when would a court actually appoint a commissioner?
Well, imagine a really complicated business dispute
Okay.
involving incredibly complex financial transactions.
The kind of thing that would make my head explode.
Exactly. And the judge might not be a financial expert themselves.
Right.
So they can bring in a commissioner.
Who's a financial expert.
Exactly. Someone who can analyze those transactions.
And explain them to the judge.
Exactly. So the judge can make an informed decision.
So the commissioner dives into the evidence,
Yes.
looks at all the detail,
They do deep dive.
and then they present their findings to the judge in a way that everyone can understand.
Precisely. Their report has to be very thorough.
It has to lay out their reasoning.
Absolutely. And the evidence they relied on.
So it's not enough to just say, I'm an expert, trust me.
No, they have to show their work.
Okay, that makes sense.
It ensures transparency and accountability.
Now, last but not least, we have Rule 33.
Demurrer to evidence.
This one is a bold move,
It can be, yes.
essentially challenging the strength of the other side's evidence.
That's right, saying they haven't proven their case.
So how does that actually play out in a trial?
Well, let's say the plaintiff has presented their whole case.
Okay.
And the defendant's lawyer is thinking, wait a minute.
Yeah,
Their evidence is full of holes.
like a house of cards.
Exactly, like they haven't actually proven anything.
So that's when they might file a demurrer to evidence.
Exactly.
They're saying, we don't even need to present a defense.
Right, because you haven't proven your case.
So it's like a shortcut.
It can be, but it's a risky one.
Because if the judge disagrees,
Then the trial continues.
and the defendant might have revealed their strategy too early,
Exactly, so it's a gamble.
it's a high-stakes gamble.
It is, but if it's successful,
It can end the trial quickly.
and in your favor.
Okay, so we've delved a little deeper into each of these 4 rules.
Yes, we've seen how they can work in practice.
But I'm curious about how these rules connect.
Connect.
Yeah, how they interact with each other in a real case.
I see what you mean.
Seems like they would all influence each other.
They do, they're all part of the same system.
We're back, wrapping up our deep dive into these rules of court.
Rules 30 through 33, a fascinating set.
Yeah, we've gone beyond just the definitions now.
Seen how they work in a real courtroom?
But I'm still thinking about how they all connect.
How they fit together, you mean?
Yeah, how they interact with each other in an actual case. Because
Yeah.
it seems like they all influence each other.
They do, they're all part of the same system.
So let's look at Rule 30 again.
Okay, the one that sets the stage for a trial.
Right, and it highlights that difference between a trial and a hearing.
A distinction that can be really important.
We talked about how trials are specifically about the evidence,
While hearings can cover a lot of different legal issues.
like pre-trial motions.
Exactly.
So that seems like a small detail.
It might seem small, but it can have big implications.
Like what?
Well, think about appeals.
Okay, challenging a decision.
The rules for appeals can be very specific.
About what can be appealed.
And those rules often depend on whether the order was issued during a trial or a hearing.
So whether you're in a trial or a hearing matters.
It matters a lot, especially if you want to appeal later on.
Makes sense.
So lawyers need to be very aware of those procedural details.
Okay, now what about Rule 31?
Consolidation and severance.
We talked about consolidation being like merging lanes on a highway,
To make things more efficient.
and severance is like split them back up.
To make sure everyone's getting a fair shot.
So what are the bigger implications there?
Well, think about legal precedent.
How a decision in one case can influence future cases.
Exactly. So if several cases are consolidated,
Uh-huh.
the decision in that combined case
Yeah.
could set a precedent for a lot of different legal issues.
Because it's like a bigger, more impactful decision.
Exactly. But if those cases were severed and tried separately,
The impact would be more limited.
right, more specific to the parties involved,
So the decision to consolidate or sever?
it can have long-term consequences.
Wow, it's not just about managing that one trial.
It can shape the legal landscape going forward.
All right, now what about Rule 32? Trial by commissioner.
Our super referee,
Right. The specialist brought in for complex issues.
like a financial expert for a business dispute,
They help the judge understand all the technical stuff.
and their reports, those can be really valuable.
Valuable how?
Well, they can influence how similar cases are handled in the future.
So other judges and lawyers might look at those reports,
They can be really informative.
and they could even shape legal policies down the road.
It's possible their expertise can have a ripple effect.
So the commissioner is not just resolving that one dispute.
They're contributing to the legal system as a whole.
That's pretty cool.
It is.
Okay, last one. Rule 33, demurrer to evidence.
A bold move.
Challenging the strength of the other side's evidence.
And potentially ending the trial early.
So what happens if a demurrer is successful?
Well, it sets a precedent.
How so?
It says that a certain type of evidence
Uh-huh.
is not enough to support a claim.
So it's not just a win for the defendant in that case.
It can affect future cases too.
It raises the bar for what counts as sufficient evidence.
Exactly. And it might even deter weaker lawsuits from being filed.
So it's more than just a legal tactic.
It can shape the whole landscape of litigation.
Wow. So these rules, they're pretty powerful stuff.
They are. They're the gears that drive the legal system.
And they're way more interesting than I thought they would be.
They're full of strategy and nuances,
It's all about understanding how they work together.
and how they can be used to achieve different goals.
Well, I think we've covered a lot of ground today.
We've gone from the basics to the bigger picture,
From scheduling a trial to the impact of legal precedent.
and the role of specialized expertise.
It's been a fascinating deep dive.
It has.
So until next time, keep those legal minds sharp.
And remember, the deeper you dive,
The more interesting it gets.